Hey everybody, this is Paul Yokubaitis from Cary Estate Planning, back with another video as part of our 2020 video challenge. And today I wanted to talk about marketing real estate after the death of a partner as opposed to a spouse. So what happens if you're in a serious relationship but not married? You live together with your significant other, your partner, and they pass away. What are your rights to their estate, to their real estate, and how do you move forward with selling that property if needed? And the first and most important general concept is that the title always controls. So it really depends on how you own that property, whether you have an interest in the property as an owner. You could own it as tenants in common, joint tenants with rights to survivorship, but it will never be tenancy by the entireties unless you're actually married. And so sometimes when it's the specific objective of a couple to not marry, they'll also follow through with different planning measures to create a lot of the same rights of marriage without actually being married. And often that will include owning property as joint tenants with rights to survivorship. So that'll be obviously the first measure, is if that's the ownership designation of your commonly owned real property, then it looks a lot like tenancy by the entireties when it comes to rights to survivorship, and that the surviving partner would receive 100% vested fee simple ownership as soon as death could be proven. So as soon as the receipt of the death certificate happens. If it's tenants in common, then you each own usually 50%. Usually people don't own uneven allocations of real property in the same piece of property. But then the deceased partner's estate would control. So it would be driven by their will or lack of will. And usually if there's a lack of will, you won't be included in it. You generally, as a partner, do not have default inheritance rights. You're not next of kin from a legal perspective. So if there's a will, though, it may name the surviving partner as the beneficiary of real property. Really depends on circumstances. If it's not owned by you at all, then you're really waiting to figure out what the estate will look like for the deceased partner. If they're 100% owners and fee simple of that home, then unless they gave you an interest in the home through their own will, you're likely to be excluded from that real estate entirely. So this really highlights the importance of proactive planning, whether you're married or not, to make sure that your ideal objective is accomplished, regardless of what happens and whenever that day should come. If you're looking at planning as a non-married couple and wanting to instill some of the benefits of marriage without actually being married, a great start is an initial strategy meeting with one of our lawyers. You can click the link below to get on our calendar, and we can discuss what planning would look like for you. This is Paul from Cary Estate Planning.